All right. Good morning, everybody, and welcome to May's risk reduction class, where we are
Morning.
Good morning. We're going to be talking about 7 very important forms. A couple of them are new, one's revised, and 4 oldies but goodies. So quite a bit of material to cover. Try to go through it quickly. Emily emailed a handout to everybody. Hopefully you've had a chance to either print that or at least access it on your screen, maybe besides this screen, multiple views or something, I'm not sure. So you can follow along on the forms and take notes. So let's get started into the material right away. Let me share my screen. Of course, as always, if you have any questions about this material or anything at all, don't hesitate to reach out. Give me a shout. Call me at the office. Email me. I check my messages regularly. If it's after hours, you can text my cell phone and I'll respond that way as well. I'm getting people who are coming into the waiting room. I guess they're being admitted. Hopefully that works. All right, let's jump right into today's session. A review of 7 very important forms. As I said, some new ones, a revised ones, and some oldies but goodie forms. All of them quite important in your transaction. So the 7 forms we're going to talk about: the home fire hardening disclosure and advisory. That's a new form, was in the December form release. We're going to talk about why that form was created and how to use it. The Fair Housing and Discrimination Advisory Form, that actually came out in October. CAR put it out right away when they felt like there was a need to address some fair housing issues. Review that a little bit with you as well. The Square Footage and Lot Size Disclosure and Advisory, that's a revised form. They've improved that considerably. We'll talk about the benefits of using that form. We're going to talk about the Transfer Disclosure Statement and the Agent Visual Inspection Disclosure and how they relate, and go over some issues with the transfer disclosure statement that frequently arise in transactions. And then finally, we're going to talk about one of my favorite forms, the Buyer Material Issues, BMI, and the Buyer's Satisfaction of Investigation. That is not a CAR form. That's a RE/MAX United form. I don't know if RE/MAX All Pro has that form. I will be sure before the end of the day, email a form that All Pro, Mary, or whoever she designates, can put that on an All Pro letterhead. You'll see what it looks like today. So let's jump right into the form. So the first form we're going to talk about is the Home Fire Hardening Disclosure and Advisory, HDDA. What is home hardening? You've probably become familiar with it. It's been a lot of talk about it lately. Home hardening is the use of construction materials or features of a property that reduce the risk of the property being susceptible to wildfires and flying embers. So in January 1st of this year, a new law went into effect that required certain sellers, depending on the property and the seller's status, and we'll review that, they are required to complete and deliver to the buyer a home hardening disclosure. So CAR created a form to accomplish that, and that's this form here. It's a 1-page form. It's fairly simple. I'm getting quite a few questions on it, and partly because I haven't done this class prior to the first of the year. So hopefully it'll answer a lot of your questions about this form. We're going to look at it in some detail here. So here's the form. So who does the law apply to? Well, the law requires only required sellers of residential properties 1 to 4 units. So a seller of land would not have to do this form. A seller of a commercial property would not have to do this form. 1 to 4 units does include condos, of course, and duplexes. They would have to do this form. So residential 1 to 4 units constructed before 2010. So if you got a property constructed in 2009, they would be required. A property constructed in 2011 would not be required. So the drawing line is January 1st of 2010. And if they are located in either a high or very high fire hazard severity zone. And then finally, if they are also required to complete a transfer disclosure statement. So what does that mean? That means transactions that are exempt from transfer disclosure statements are also exempt from this law. So that would include probates. That would include, of course, REO sales, and it would also include irrevocable trust sales most of the time. Revocable trusts probably would still have to provide this form, because revocable trusts in general need to do real estate transfer disclosure statements, unless it's a successor trustee who is liquidating the assets of a deceased person. So that's who the law applies to. So now, where do you find out whether you're in a high or very high fire zone? Well, check with the natural hazard zone disclosure company, or view your natural hazard zone disclosure. So that should be ordered quickly. So you can consult that and then determine whether you're required to make this disclosure or not. If you are in a high or very high fire zone, you are required. Now, there's a bit of confusion relative to the civil code and the natural hazard reports. The civil code recognizes 3 distinct fire zones. One is the high zone, the other is the very high zone. There's also a moderate zone, a moderate fire zone. Interesting enough, the law does not require this disclosure in a moderate fire zone. However, the natural hazard reports generally lump high and moderate in a single category called wild land fires. So you may have to go through your natural hazard disclosure to determine whether it's in a high or a moderate. There's a box that's checked very high. That'll be very easy to determine. But if its box is checked wildfire, then you have to determine whether it's high or moderate. However, you might err on the side of caution. We're going to talk about that in a minute, and just deliver the form anyway. There's no downside if you do it correctly in a timely manner. So you can also, you can talk to your natural hazard zone natural hazard company representative and ask them to check for you. But I would have them confirm that in writing. But again, I think err on the side of caution and provide the form if there's any question. All right. Now, the form makes a affirmative statement that the home is in a high or very high fire zone, unless you check this box. If you check this box, you can still deliver the form, but you check the box, it's not in a high or very high fire zone. If you don't know, don't check the box, deliver the form anyway. There's, again, no downside to delivering the form in a timely fashion. And in fact, that's what paragraph 4 talks about. Even if the property is not in one of those zones, the property could be near mountainous areas, forest-covered lands, brush-covered lands, grass-covered lands, or land that is covered with flammable material, which includes a lot of just about any property in Riverside or LA County or San Diego County, probably. So giving this form is probably a good idea, even when it's not required. At United, we're actually requiring this form in our files. I'll talk to Kenny on whether or not this should be a requirement for all pro. erring on the side of caution would be the right way to do this, handle this. Okay, so the disclosure contains the civil code mandated statement, and the civil code requires that this website be provided to the buyer, and this website provides lots of information about wildfires. So you're complying to civil code when you deliver this form. Civil code also requires the seller to answer questions about fire hardening features. Now, the questions are asking if the seller is aware of the following features. If a seller is not aware of a feature, he's not saying it does or doesn't have a feature. She's not saying it does or doesn't have a feature. She's saying whether or not she's aware of the features. And of course, there is these features make the home susceptible to wildfires and flying embers. So there's a list of these features, and you check all that apply. So if you have eaves or soffit or roof ventilation or vents that have openings in excess of 1/8 of an inch and are not covered with a flame-resistant screen, then you check that box. Roof coverings made of untreated wood shingles or shakes, you check that box. Combustible landscaping within 5 feet of the house, single-pane windows, loose or missing bird stoppings. I would submit that most of your sellers have no clue as to whether they have loose or missing bird stoppings or roof flashings. They might know whether or not their rain gutters have covers on them or not. So those are the questions that the sellers must tell buyers if they're aware of these things. Now, like I said before, check all that apply. So you could have a form where a seller might have several boxes checked because, I do have single pane windows. I do have rain gutters without coverings on them, and I have a wood shake roof, and I got bushes right up against my house. So that you check all that apply. Now, paragraph 323 discusses a home fire hardening final inspection report. This causes some confusion with agents. There's no requirement to get such a report. But if the seller has such a report, then the seller is obligated to either provide it, or if the seller can't find it, state where a copy of the report can be obtained. All right. Then the seller is provided answer to this form to the best of the seller's knowledge. And it's as simple as that. A lot of people panic a little bit because their sellers don't know. Well, you know what you know. You may not know for sure whether you've got loose bird stoppings or flashing on your roof, but you know if you know or not. So that's what, again, to the best of your knowledge, what are you aware of? So that's the HHDA, the Home Fire Hardening Disclosure and Advisory. Pretty simple, straightforward form. Any questions that you want to interrupt me now? We'll run that form, or we can wait till the end. If you want to wait, we can do that. Maybe that's what we'll do. Okay, so the next form I want to talk about is the Fair Housing and Discrimination Advisory, the FHDA. Now, this form is not a result of any new laws. This form was created by CAR to better explain fair housing to clients and, for that matter, agents. So they put together this form. It's a 2-page form, and it has a lot of material. I'm going to zoom through it. I don't want to spend a ton of time on it, but I'm going to point out a few things. I recommend that you read through this and understand the provisions of this form, and of course, provide it to your clients. Now, it's pretty easy to provide it to your clients because this form prints with, I believe, about 20 or 21 different CAR forms. Every listing contract and buyer representation agreement includes this form. Every type of purchase agreement includes this form, and all rental agreements and property management agreements include this form. So you'll get this form almost always as a result of doing real estate activity, and of course, you provide it to your client. So let's look at the form in some detail. The form starts out by stating that it's, that equal access to all, to housing for all is a California law. And there are also several other federal and state laws that prohibit discrimination and identify protected classes. And so this is a listing of all the different laws that are a part of fair housing and anti-discrimination when it comes to housing. It's important to note that a lot of times when you goof up in real estate, the penalty is basically monetary damages. But if you goof up with fair housing regulations, you could be subject to fines, injunctive release, punitive damages, and even possibly you could have your license affected. So be very, very careful and not commit to any prohibited act when it comes to fair housing and anti-discrimination. Now, what are the protected classes? In the state of California, there are 21 named protected classes. Here they all are on this form. And a general protected class. Any arbitrary characteristic that you discriminate against is also illegal. So you can't whimsically just decide you don't like somebody and you don't want to sell to them. You got to be sort of careful. It's a very broad catch-22 type of clause, the any arbitrary characteristic. But the other ones are quite, enumerated here and pretty specific. The most recent one that was added to this list is military and veteran status. A few years ago, criminal history is also, you can't discriminate against somebody due to their past criminal history for non-relevant convictions. If their conviction is relevant to what they're trying to, do in real estate, there could be a cause to discriminate, but in general, no. Section 8 housing is another recent law. You cannot discriminate against somebody who is paying their rent with Section 8 funds. And in fact, city of San Diego passed a very stringent city ordinance that one of our agents, actually a team, got caught on right at the beginning of last year. And we had to settle right away because the law is pretty strict and there's no defense. If you advertise no Section 8, then you're automatically guilty and you owe twice the monthly rental to whoever reads the ad. It's a pretty broad law. So if you come upon that, give me a call. We'll talk about that. So anyway, these are the protected classes. Now, like I said, you can get in trouble with the DRE if you violate this as well. And of course, you can also get in trouble with your NAR membership. Okay, who's required to comply to fair housing laws? Well, you can see there's quite a list. The ones that we're most concerned about are sellers. We don't want our sellers to inadvertently violate fair housing laws. We don't want our landlords, and of course, real estate licensees and brokerage firms. I would also point out property managers. You want to be very, very careful because these laws affect all these people, are all required to comply to fair housing laws. The form goes on to list some examples that may not be motivated by discrimination intent, but could have a discriminatory effect. Now, this has come up recently because of the so-called buyer love letters. The accepting and reviewing buyer love letters by sellers could lead to inadvertent discrimination, even when the seller didn't intend to. And so there's a general advisory against not providing these kinds of letters that, for most of us have been doing real estate for a while. We've been teaching or practicing providing a letter with your offer to introduce the buyer to the seller and hope, maybe your buyer stands out just a little bit over all the other offers. That is not illegal. I want to point that out. In a webinar I did last Wednesday, I talked a little bit about how if you are inclined to want to do it, I mean, first of all, I advise you probably shouldn't, but if you are, it's not illegal. You just have to be very, very careful. And the point is, you do not want to in any way reveal the status of the buyer relative to protected classes. So a photo would, of course, be prohibited. Saying my family loves the property would be prohibited. Why? Because that is a familial status. So if the seller picks somebody who didn't have a family over somebody, or rather pick somebody who had a family over somebody who did not have a family, the person who did not have the family might have a cause of action that they were discriminated against because they didn't have a family. So, saying my family loved the home, can't do it. Now, it's interesting. I saw one buyer love letter where the buyer got around it kind of clever. My dog loves the property. My dog just thinks your yard is wonderful. So, there's nothing wrong with that, I suppose. So, but be careful with buyer love letters. In general, you should probably not do it. And you should have the seller instruct you in writing not to present these buyer letters to the seller. All right. Some examples of unlawful conduct based on protected characteristics, and it lists several here on the first page, and then on the top of the second page, it just lists. Most of them make common sense. Inquiring about the protected characteristics of either a buyer or a tenant. Are these people Hispanic or not? That would be a horrible question to ask, and so that is outright illegal. And so it lists what would be a violation of the law on that form. It does give some examples of things you can do to positive practices to avoid practicing discrimination. And then it gives some resources of where you or your client can go to get more information about fair housing and anti-discrimination. And then there are some exceptions to fair housing, but I want to point out, don't pay too much attention to these exceptions with the following exception. And that is, notice that some of these exceptions, if a real estate agent is involved, then that exception does not apply. In other words, anytime a real estate agent is involved in any kind of real estate transaction, there is no exception to fair housing and anti-discrimination law. So govern yourself accordingly, of course. Okay, so that takes care of the FHDA, the Fair Housing Form, fairly straightforward form. Recommend you do take a moment and read through it. This next form is a fantastic form. And again, RE/MAX United, we are now requiring this form. Again, I'll talk with Kenny and see whether he wants to do the same thing at All Pro. I can tell you that issues over square footage and lot size are not uncommon. And relative to a buyer seeking damages because they were misled about the square footage, that can be pretty significant, with construction costs topping $350, $400 a square foot. Doesn't take a rocket scientist to figure out how big a check you're going to have to write if you made a 200 square foot mistake or misstatement regarding square footage. The dollar damages can get pretty high pretty quickly. So it's a good idea to include this form in all your transactions because it's going to give you a level of protection against buyers making claims about the square footage of the property not being what they thought it was. So let's take a look at the form. The first thing the form talks about is there is no official size source. In other words, there's no source of square footage that is the official square footage. An appraiser can say one thing, the tax roll can say one thing, a building permit can say another thing for a remodel, a builder's brochure can say another thing. So there's no official square footage. And there's no standard method of calculating square footage. Appraisers have a fairly universal system in California. I can tell you appraisers in other localities, other states, do square footages a bit different than we do in California. So there are some accepted practices for measuring square footage, but there's no standard method. So this form points out, look, there's no unique definitive source or way of calculating the number. Sellers should not rely on advertised or disclosed square footage measurements. That's a nice disclosure to make. And they should retain their own experts. If square footage is important to them, they should measure for themselves. Now, it's the same with property lot sizes. Fences, hedges, walls, that sort of thing may not correspond to the legally defined property boundaries. And in fact, existing structures may not even be within the property boundaries. We've had more than a couple of lawsuits over the years at RE/MAX United with overhangs, and in one case, an actual garage sitting on the neighbor's property. The neighbor didn't care. The seller and the neighbor got along fine. When the new buyer bought the property and discovered the garage was partway on the other, on his neighbor's property, that was a big problem for us. So, these things can occur. So if it's important to the buyer should independently investigate by retaining the services of a surveyor. The only professional, I didn't underline that, but the only professional who can accurately determine lot size. That's the only way to determine it, is to have it surveyed. Okay. A broker's obligations. What are our obligations? Well, we do not have expertise in determining exact square footage and lot size. And we have not and will not verify the accuracy of any numerical statements regarding square footage or lot size for that matter. So again, nice disclosure right up front. Now, paragraph 4 of this disclosure is very, very helpful. I get questions all the time. Walt, I have multiple sources of square footage, and they're all different. Well, this form allows you to list all of those and to discuss what those sources say. So if, public record says one thing, the previous MLS, this comes up all the time, the old MLS, when they bought the property 4 years ago, 5 years ago, has a different number than the number I'm coming up with. So, multiple listing services, appraisers, drawings, permits, whatever the source of square footage, it gives you a place where they're listed. You got a couple of other blanks. Then the square footage or lot size, you can state what those are. Any additional comments you can make on this form. Note that if the seller is providing the square footage, then you want the seller to provide the source. Where did the seller get this? Oh, I just made it up. Well, we probably shouldn't disseminate that information, but no, that's from my remodel when I got a permit, or I had the house refied, and that's an old appraisal. Okay, well then of course you would provide that, but what is the measurement source that the seller is citing when the seller does it? And then, of course, if you have copies of these sources, then you check them, and you can check each one. I just checked the top one and provide that copy as well. This question that came up recently, and I think it's an important answer, important to note. If the buyer had a home appraised, of course he probably did, or the lender did when he bought the home, and he has a copy of that appraisal, that is a square footage source that the buyer can and should disclose to a future buyer. So you don't have to give them the entire old appraisal. It probably wouldn't matter anyway, because prices have changed over the years, obviously. But that square footage on that old appraisal is what's called constructive knowledge. That's information that you have in your possession, whether you realize it or not. So you can never read a physical inspection. And I've actually recently had a buyer who paid for a physical inspection, and then both the husband and wife admitted to me after close of escrow, neither one of them read it, which was sort of shocking. Why would you buy one and not read it? Well, the problem the buyer had was, now there was information that he was told by the listing agent that was inaccurate. But the physical inspection corrected that misinformation. Again, the buyer didn't read it. I had to explain to the buyer that you had what's called constructive knowledge of the accurate information because you had that information in your possession by virtue of the fact you had that physical inspection that corrected the mistakes the listing agent made. So I argued you're welcome to get your own attorney if you want, but I don't think you're going to go very far with a claim against the listing agent because the physical inspection gave you, again, constructive knowledge of what was in fact accurate. So an appraisal from before, you refied it before or when you bought it, you have constructive knowledge of a square footage. And that number may be a little smaller than what the MLS says from the previous time or what the builder's brochure said. You would want to provide both. And you provide all of the square footages that you are aware of. And in fact, when the seller signs this, they're representing that they're not aware of any other measurements of the property. They're not aware of anything else that provides data about the size of the property. Better to disclose all than to hold one back and then have that bite you later. Okay. And then by signing below, the buyer acknowledges and understands that if square footage is important to them, that they should investigate the validity and accuracy of any of the measurements they were provided. And if they don't investigate the accuracy of any of the measurements they're provided, they're acting against the advice of the broker. That's a nice disclosure at the bottom. All right, that completes the square footage and lot size disclosure. So those are the two new and the one revised form. Now I want to give you a quick review, if you will, and we're actually doing great time-wise. I want to talk about the TDS and the agent visual inspection, especially relative to the TDS. And the reason I want to the reason I'm bringing this up is, I know most of you, if not all of you, are very familiar with the TDS, and so I'm probably not going to share with you much that that you may not already know. But I do want to talk about some mistakes, if you will, some issues, maybe a better word, surrounding the completion and delivery of the TDS that can get you in trouble as an agent because we're the experts. Our sellers rely on us. And for that matter, not reviewing some of this with our buyer clients could also cause us problems. So let's take a look a little bit about, let's look at the TDS and talk a little bit about specifically what I'm talking about. So as you know, the TDS is a 3-page document, and there are several sections to the TDS. The TDS is discussed in Civil Code 1102. And in that Civil Code, here's the agent visual. Let me get ahead of myself a little bit. In that Civil Code, it talks about exactly what must be provided for a TDS to be delivered. So a TDS is required on certain types of properties. Basically, 1 to 4 residential units requires a TDS. And if the seller is not exempt from a TDS, then they must provide it. But simply providing the form and not completing it constitutes non-delivery. In other words, it doesn't make for delivery. So believe it or not, one of the things that I frequently see missing from a TDS is the date that the seller is saying this is the condition of the property as of this date. If this date is not filled in, you have not delivered a TDS. You provide a buyer a TDS and this is blank, the buyer is never given the TDS. Now, why is that critical? Well, it's critical because the buyer removes all their contingencies and then they change their mind and they want to get out of the transaction and they want their deposit back. A sharp agent, I'm not saying I'm sharp, but I've used this. Hey, Mr. Seller, Mr. Listing Agent, you did not deliver the TDS to us because you didn't put a date in here. Once you put a date in here and give it to us, the buyer has an unconditional 3 to 5 day right of rescission when the TDS is delivered. So now you deliver the TDS to us with the date, and now the seller rescinds. And there's no requirement for the seller to act in good faith. That's not part of the code. I don't want to say there isn't a requirement for, the buyer rather. I don't want to say the buyer is not supposed to act in good faith, but what I'm saying is the code is very straightforward. Upon delivery of a TDS, the buyer has an unrestricted right of rescission, depending on how it's delivered. 3 days delivered in person, 5 days delivered by email or mail. By the way, I forgot to mention, let me jump back, the home fire hardening disclosure, that is part of 1102 also. So that disclosure contains the same right of rescission. So that's why I said earlier, if you deliver that form early in the transaction, even when you didn't need to because you couldn't determine what fire zone it was in, there's no downside. You deliver that form late in the transaction, and you're not sure what zone it's in, there could be a downside because delivery of that form gives the buyer an unrestricted right of rescission. And of course, you deliver it within your 7-day window. They got 17 days, so it doesn't matter. Your 7-day window, how soon you must deliver as a seller or listing agent all the disclosures, and then the buyer has an additional 10 days for a total of 17 days to investigate. So you deliver the HHD or the TDS within that 7-day window, the right of rescission is not a problem for you. Deliver the TDS or deliver the TDS incomplete, not filled out completely, that's a problem for you because you haven't delivered it if you don't complete the TDS. All right, so number one, make sure the date's in there. The other real common mistake, and it's because we got used to ignoring section 1 of the TDS. Civil code requires that for a TDS to be delivered, sections 1 through 3 must be complete. If section 1 is not complete, you haven't delivered a TDS. We're looking at section 1 right now. Section 2, we'll cover in a minute. That's where the seller answers a bunch of questions. If that's not complete, you haven't delivered the TDS. And if section 3 is not complete, that is the listing agent's visual inspection. If that's not complete, you haven't delivered a TDS. Now, interestingly enough, there's also section 4, which is the buyer's agent's visual inspection, but that does not have to be complete to have an effective delivery. Now, if you think about that, that makes sense. Otherwise, a shrewd, I won't say smart, I'll say shrewd, crafty buyer's agent would never complete their section of the TDS, which is section 4, giving their buyer a right to rescind right through the whole transaction. I'm not going to complete section 4 as a buyer's agent till the day before escrow closes. That way my buyer would have the entire escrow to rescind this purchase agreement. Well, the civil code's smart enough to say, look, buyer's agent, your completion of the TDS is not necessary for the TDS to be delivered. But civil code does require you, Mr. or Mrs. Buyer Agent, to do your AVI as well. And we document that on an AVID. Hope that didn't confuse anyone. But sections 1, 2, and 3 must be complete or you haven't delivered a TDS. So section 1, it discusses substitute disclosures. Now, the problem with the phrase substitute disclosures, and you get a bit into the weeds, don't get hung up on it. When the TDS law was passed nearly 50 years ago, I think, the legislature, required the seller. This form, by the way, is pretty much, well, not pretty much, it is what I call codified. This exact look of this form is in the civil code. Like the home hardening disclosure, a phrase or two is in the civil code. The RPA, the Megan's website, that's in the civil code. But what a purchase agreement looks like is not in the civil code. Just you have to have in the purchase agreement, or you have to give to the buyer. You don't have to do it in a purchase agreement, but if you don't, you have to give them in a separate document the Megan's website information. the TDS, this exact look, if you went to 1102 of the Civil Code and zoomed through the first 10 or 12 pages, pretty soon you're going to stumble upon something that looks exactly like this. It won't have the California Association on it. It won't have car TDS. It won't have this on it, but it'll have all of this. It'll look exactly like this. Okay, so the Civil Code, they passed the TDS law and they required the seller to answer a bunch of questions. Those are in Section 2. We'll look at them in a minute. They also included a Section 1. And what they thought was, if a seller couldn't answer all these questions, they could hire somebody and they would answer all the questions for them. And of course, maybe we would have inspectors who would be willing to, complete this form by making a substituted disclosure of all of the information that the TDS requires. So they come up with this phrase, substituted disclosure. Well, guess what? The inspection industry, they immediately said, there's no way we're going to make disclosures on behalf of the seller. So in the history of real estate in California, no substituted disclosures in lieu of the seller's disclosures have ever been made. But the form had the ability for the seller to provide substituted disclosures and check a box. What the form didn't have initially was the statement "no substituted disclosures." That was added to the form last year, at the end of last year, actually the end of the year before last. But because there was no requirement, no substituted disclosures, rather, that sellers had or listing agents had, they just ignored this. And so agents have gotten into the habit of ignoring Section 1. Code doesn't allow you to ignore it. The code recognized why it was being ignored because you may not have a substituted disclosure. So at the end of 19, I believe, they mandated that there be another box added, no substitute disclosures. Okay, so you can complete this form by, number one, checking the box if you're providing inspections reports pursuant to the contract for sale. In other words, if you have a report that the contract requires you to provide and you already have it, you can provide the report with the TDS and check this box. If you have additional inspection reports, the contract doesn't necessarily say you have to provide it, but you have those reports and disclosures, you can check this box. Now, this is where you would list a previous physical inspection from a buyer who canceled escrow. And then finally, if you didn't have anything that you wanted to add to this disclosure at this time, this TDS, you would check this box. No substituted disclosures for this transfer. One of these boxes must be checked, or you have not completed Section 1 and therefore have not completed delivery of the TDS. I have used this so-called technicality twice to get leverage on sellers after buyers had removed all their contingencies and then had issues. And the seller basically said, I don't care. If you don't close, I'm going to keep your deposit. I was able to argue, since you didn't complete Section 1, when you do give us Section 1 completed, the buyer will cancel unless we resolve these issues. Or if you never do it, well, then you've never given us a TDS and we can cancel pursuant to not getting a TDS. Even though we got a document, it wasn't complete, so it wasn't delivered. Hope I didn't lose anybody on that. Okay, Section 2 is the seller's information section, and that's where the seller answers a bunch of questions. And the one that is sometimes missed, and the one that buyer's agent should make sure the buyer is aware of, whether the seller is or is not occupying the property. Obviously, a buyer's representation on whether or not there's any problems with all of this stuff is going to be affected by whether or not they lived in the property or living in the property property at this time. If a buyer's never lived in the property, they may not know if there's a problem with some of this stuff because they don't live in the property. And so a buyer should be advised that the seller may not be able to make a good representation on whether he's aware of a problem, or he can make a representation whether he's aware or not, but you won't, he may not be aware of something that is a problem that if he lived in the property, he would be aware of. Hope I didn't mumble through that too quickly. So the subject property has following items, and then you check all the things the property has, and that continues on down to the bottom of the page. And then, to the best of the seller's knowledge, any of the above not in operating condition. So if you say, yes, something's not working, the garage door opener doesn't work. So you have a garage door opener, so you check that box, but it doesn't work quite right. So you would check that. Now, if you check that, you must explain, then describe. If you don't describe it, you've not completed the form. And again, listing agent should make sure that the seller, when he checks stuff up here, he'll check a bunch of stuff up here. And if he checks, yes, there's a problem with one of my items, then make sure he's also provided an explanation. A buyer's agent should look at that explanation, and if it's not there, seek it out. Please explain what is the problem with the garage door opener. Okay. Are you aware of any significant defects in any of the following? So you're not checking that the house has these things. Of course, the house has interior walls, it has ceilings, it has floors, it has roofs. What you are checking is, yes, I got a problem with the roof. And then if you say I got a problem with the roof, you would check the roof, check the appropriate space, the thing that had a problem, and explain rather, what is the problem? You check the roof. You said, yes, I got a problem. I got a problem with the roof. Yes, I got a problem with the fence. The fence is falling down. Explain, fence is falling down. So you've got to answer that. Civil code says if any question is not answered, the TDS is not delivered. Okay, then part C of section 2 is the seller aware of any of the following? So again, you can't know what you don't know. From time to time, you'll have a seller say, well, I don't know if there's fill on my property. How would I know? Well, it's not asking you whether you know whether there's fill or not. It says, are you aware that there's fill on my property? And so, yeah, I am aware, as a matter of fact. Then you would check yes. But if you're not aware, you could say no, even though there is fill, but you're not aware of it. Okay. So that completes the 16 questions. It goes on the form, and then if you answered yes to any of those 16 questions, then you have to explain here. And that's what's frequently missing from TDSs. We see yeses, sometimes we see a yes checked, and they just restate yes, fill. Well, explain that. You said, yes, you're aware of fill. Putting fill down here doesn't really explain it. So you want to explain it as you complete the TDS. Finally, as you well know, the TDS has a place where you can certify you have operating smoke detectors and that your hot water heater has been strapped and braced. And then the seller certifies to the best of their knowledge that this is accurate information. All right, section 3, remember, first 3 sections must be complete if the TDS is to be delivered. And so section 3 is for the listing agent, the agent who represents the seller. If there is no listing agent, then section 3 does not have to be completed. But if there is a listing agent, then the listing agent should attach an AVID. That's what we require at both RE/MAX United and All Pro. Some agents don't. But if they don't attach an AVID, then they should be making notes on this form. By the way, we don't allow that because there's not enough room to do a good job with your visual inspection. Hopefully nobody checks no items for disclosure. That would be pretty sloppy. Section 4 is for the buyer's agent. And again, the buyer's agent is required to do a visual inspection. They would attach their AVID, but that does not have to be attached for a TDS to be delivered. And then finally, there's a disclosure that the buyer should seek the advice of professional inspectors and not rely just upon what's completed in the TDS. And then they discusses Civil Code 1102, a buyer's right to rescission, when this is delivered, if it wasn't delivered prior to the buyer entering in, writing up an offer. It has to be delivered prior to the buyer writing the offer, not prior to the offer being accepted. That takes care of the TDS. The AVID is, I'll go through it very quickly, just since we're talking about it. The AVID is a part of the TDS when it comes to listing agents, and should be a part of the TDS when it comes to buyer's agents as well. So one of the things that I get questioned on all the time, civil code, and I'd like to see this corrected, but I'm not sure I have enough clout with the legislature. They're going to correct this. Civil code does not require more than one TDS per parcel number. Of course, you don't do TDSs on vacant land, but if you have a home with 3 units and that's one parcel, civil code requires only one TDS, but you would have to describe on the TDS which parcel which unit you're checking yes and no to. I would recommend you do 3 TDSs, one for each building on the property, but you can't require it. Not the same with visual inspections, with the AVID. With the AVID, if it's a duplex, a triplex, or a fourplex, then this AVID is only for one unit, and you add additional AVIDs for the additional units. So if you have a 3-unit transaction, it's possible to have one TDS, but you would have 3 AVIDs. Or if you're the listing agent, you would do 3 AVIDs. And again, I would recommend you do 3 TDSs and clearly mark which unit each TDS is for, but that's not legally required. All right. What does the law require? It requires a reasonably competent, diligent visual inspection of reasonably and normally accessible areas. So you don't go under houses, you don't go in attics, you don't even have to open up cabinet doors to do an inspection. You disclose to the prospective purchaser any material facts affecting the value or desirability of the property. And it applies to either agent. It doesn't matter who the agent represents. In other words, both agents must do a visual inspection. And residential properties containing 1 to 4 units and manufactured homes, civil code requires a visual inspection. Now, you do not inspect areas that are not accessible off-site of the property. You do not review public records or common areas of condominiums. So that's not part of your inspection. Don't inspect that. Once in a while, I see AVIDs with this information on it, and you've got to be careful with that. If you are aware of an adverse problem, then you do need to disclose it, but you do not have to make an investigation. But an AVI, you do investigate the property, but it's a visual. You walk around, you look at it, but you do not have to investigate the common area. But if you happen to know for a fact that there's a problem in the common area, you would have to disclose that. Hope that's sort of clear. Okay, this discusses the limitations on what you don't inspect, basically. Read through that if you have any questions. And then finally, there's another area where you can list the unit number if it's multiple properties, duplexes, triplexes, or fourplexes, and then who did the inspection, the firm, and then the agent, and the date and time, and the weather conditions, and anybody else who is present. Okay, then there's a place, and you're familiar with this, all these blanks where you can write down anything you observed. Nothing noted is sometimes put in there. It's a good idea to put something, inspected. Some people write the word inspected. They don't write anything, so one would assume that you didn't see anything. Some people just put a check next to them. It's nice because it can demonstrate that you're methodical and looked at the entire property. So somehow indicate that you looked at all these areas. And then you got places for additional rooms. And then finally, the garage and the parking and the exterior of the building, the yard, not the neighborhood, but the yard. You do inspect the yard, you do inspect the garage. And then if there's anything else you want to disclose, you could do that on this section here. This is, the firm who did the company that you're with, so either United or All Pro, and then the signature of the agent who actually did the inspection and the date of the inspection. And then another advisory to the buyer: this does not replace a physical inspection, and they might want to hire a professional to take a look at the property. And then everybody signs acknowledging getting the copy. Okay, and then finally we're going to wrap up. May take a couple of minutes over noon, but the buyer material issues and the buyer's satisfaction of investigation. I want to talk about that. Like I said, this is one of my favorite forms. Why? Because I can probably rattle off a half a dozen lawsuits, not just complaints, but potential lawsuits where attorneys alerted us that they were going to be filing a lawsuit unless we did something. And we were able to avert that. In one case, a lady went through 5 attorneys. None of them would bring a lawsuit. Unfortunately for the agent involved, the buyer went to small claims court. But here's the good news: she lost in small claims court. The buyer material issues was fundamental in our defense of that particular situation. I can name other situations. I don't want to, tell stories here, run long, but I can just tell you story after story of where we nipped it in the bud, so to speak, because what am I talking about? Here's a common practice of buyers. After a buyer closes escrow, they discover something. I'll give you a quick example. We had a buyer discover after close of escrow that they couldn't have horses. It was amazing because the property had a corral. And so the buyer just assumed they could have horses, I guess. They didn't. They couldn't have horses. They closed escrow. When they went to get a horse, they found out they couldn't act. They wanted to buy 2 horses. They had 2 daughters, and they wanted to give their daughters horses. They found out they couldn't have horses in that property. The buyer wanted to file a claim, hired an attorney, and wanted to sue us because we were the buyer's agent, by the way. We were the buyer's agent, and the buyer made the following statement. I told my agent that one of the reasons I was buying this property was I wanted to buy horses for my daughter. My agent knew that, and my agent didn't do anything to, quote, protect me. My agent didn't check into that for me. My agent allowed me to buy a property. I can't have horses. I call it selective memory. Now, if that were true, I would say shame on us and shame on our agent. But the agent involved was a good agent. The agent said, Walt, it never came up. It never came up. I didn't even think about it. They didn't say a word. Fact of the matter is, if I had to assume, I would have assumed she could have horses on the property. But I don't have to investigate the property relative to whether they can have horses or not, do I? No, unless the buyer had told you in advance that was important to them. So let's look at the BMI. The BMI had something about the water bill, the cost of water to irrigate the property. It had nothing about horses. And they said they would have never bought the property if they knew they couldn't have horses. Well, isn't that odd? You didn't list it on the BMI. That's where you tell the buyer in writing, I will not buy a property if I can't have horses. But you didn't say that. You expressed an issue about you were concerned about what the water bill was. By the way, we got a copy of the water bill. As a result of the BMI, we made sure to ask for one. So the BMI saved the day. Simple as that. It protects the agent from a buyer with selective memory who ends up with a property now they're not so happy with, and they want to blame their agent for why they weren't, quote, protected. So let's look at and then going along with that, there's a form called the Buyer Satisfaction Investigation, and I'll provide this in a Word document to All Pro so that you guys can have the same benefit of that, and I'll show you how it works. Okay, so you identify the buyer and you identify the agent, and the fact that the buyer is either contemplating making an offer, has made the offer. Usually, I mean, you can do a BMI when you're looking at property, but it's critical to do the BMI once you're in, once you've found the property. Now, you do the BMI immediately after going under contract. I like to say there are 3 things you should do immediately upon getting your offer accepted as a buyer's agent. Every buyer agent does number 1. Make sure your buyer applies for their loan if they haven't already. Number 2, not so common, buyer should get his insurance lined up immediately. Finding out about undisclosed claims 3 days before escrow closes is a nightmare. Finding out about an undisclosed claim, and I'll give the seller the benefit of the doubt, the seller simply forgot, didn't disclose the claim, or the seller sort of downplayed the claim. Yeah, we had a little leak over there in the downstairs bathroom. We found out it was I don't forget now, $200 and some $1,000 claim, $150,000 claim. That's more than a little leak. But we didn't find that out until, quite frankly, in this particular case, contingencies were already removed. And then we found out because when our buyer went to apply for insurance, their insurance company said, "Hey, we need a lot more information about this big old nasty claim." So number 1, buyers should apply for their loan, of course. Number 2, buyers should arrange for their insurance. Doesn't cost them anything. They don't close. They're not out a nickel, but they do that early. Number 3, you have the buyer fill out a buyer material issues form. I can always tell when it's done late. And by the way, done late, it could be a problem, actually. When it's done after the physical inspection, BMIs tend to look like repair requests. That's not what the BMI is for. The BMI is for telling me in advance, immediately, now your offer's been accepted. What concerns did you have going into this that you might not want to close if you got information that you weren't happy with? What's going to contribute to whether or not you want to proceed or not? Or, gee, Walt, I don't know. I want to know the condition of the property. Well, then write that down. Physical condition of the property. Maybe write down physical inspection. But tell me in advance. 50% of the time, the buyer's going to say, "I don't have any special issues. I'll wait until the physical inspection gets done." Okay, that's not what the BMI is for. You don't have anything. See, that where it would be good is, I want to make sure I can have a horse. I want to make sure. I want to make sure this house doesn't have septic. I know the MLS says sewer, but, last time I bought a house, they said sewer, and it's on septic. And I wasn't too happy about that. I want to make sure this time it's not on septic. Okay, we'll put that down. No septic. Because once you have the BMI filled out, then that's what you use to be sure that you help the buyer investigate those issues. Okay, so the next paragraph, the buyer is to disclose anything that the buyer would consider a material issue going into this transaction. All right, now here's where the buyer lists those things. And this form actually has a lot more lines, but I couldn't fit it on my slide. But this is where the buyer would write what their issues were. And it could be either any property or the property specified above. And that's usually what you do because you do the BMI once you've had an offer accepted. Now, on the form, the buyer lists their material issue concerns, not you. So if you're doing DocuSign or a digital thing, you create a text field and then the buyer types in. Interestingly enough, when we were in court, we used the BMI in our defense, and the buyer tried to claim that our agent filled that out, not the buyer. But we were able to document to the court's satisfaction that that wasn't the case. Now, if they're doing it longhand, that's going to be real simple. If they're doing it with DocuSign, then the fact that I can tell you that the font is different, and it's noted that this information was inputted on the form by the buyer. So we have a legal paper trail that the buyer listed this information, not the agent. So you don't list what the buyer tells you. Back to my horse story, if the buyer were to do this correctly, if they were, being, honest and fair up front, I don't want to buy a property if I can't have horses. They would have typed on, I want to be sure I can have horses, whatever words they want to use. And that would be a text field that you create to fill up all these blanks. Now, if the buyer has no specific issues, then have the buyer type in or write the word none. A blank form here, if 3 is blank, you open up the ability for the buyer to say, I didn't understand the form. I didn't put anything on it because I didn't understand it. Even when I explain it to agents, a lot of agents have trouble with this form. Clearly, a buyer is going to need a little help sometimes on understanding what they're supposed to do. If they write none, then they're indicating they understand the form and they're responding. No special issues. Doesn't mean they won't investigate the property. Doesn't mean they won't get a physical inspection. Doesn't mean they can't make repair requests. There's just nothing up front that they're concerned about. We had one buyer list about 10 different inspections, everything from radon to asbestos, all of these things. He just, he went wild listing all the things he wanted to investigate. When our agent, a very good agent, when our agent said to the buyer, okay, we got to go online and find some inspectors here and we got to figure out, get some estimates. The buyer said, well, wait a minute, isn't the seller doing these investigations? No, these investigations you would be doing. These are ones you want, you got to do them. Oh, well, if I got to pay for them, I don't want any of them. Okay, well, there's a form to cover that, and we'll get there in a minute. But, they list whatever they think they might be concerned about going in. Okay, the scope of duty of the buyer, and I'm not going to spend a lot of time reading each of these, but this form has a great listing of all of the obligations a broker has or what they don't have. So the buyer agrees that the broker does not decide on the price, does not guarantee the condition, does not guarantee the performance of inspectors or repairs. It does not obligated to conduct and investigate inspection of common areas, not responsible for defects in common areas, off-site defects, not already aware of, not responsible for looking at public records, especially permits, not responsible for locating the boundary lines, not responsible for square footage, representation, not responsible to give legal or tax advice. This is nicely listed on this form of what you're not going to do. And if the buyer has concerns about those things, they need to investigate that themselves. We're not going to be responsible for providing any information beyond what we are required to know to be licensed. Okay, we do not have a duty to investigate or inspect for environmental hazards or earthquake weaknesses or geological seismic hazards. The buyer representations, this is critical. The buyer has disclosed to the broker all material issues, and the broker is entitled to rely on this disclosure as to what we need to be sure that we assist the buyer in investigating. Again, we don't investigate it, we insist the buyer in investigating it. And then the acknowledgement. The buyer has read, understands, and accepts all the foregoing. So that is, that in a nutshell, the BMI, very, very good form. Highly recommend it. We've used it successfully multiple times at United, All Pro. If I had any control, I would suggest to Kenny that be a required form as well, but that's not my call. Now, if you do a BMI and it has anything other than none on it, then you have to follow it up with a buyer's satisfaction of investigation. This isn't a CAR form. It should be, but it's not. I, with the help of our attorney at the time, created this form to address issues in the BMI. So the buyer lists something in the BMI. We want to make sure we document that the buyer is satisfied that those issues were adequately investigated and the buyer wants to proceed. So this form is critical. It goes hand in hand with the BMI. When the BMI has anything on it other than none. If the word none or no specific issues or whatever the buyer wants to say that indicates none, if the BMI has that, then you don't need this satisfaction of investigation. But if it has something on it, then you need this form. And so the form starts out by saying you previously on either the BMI, and we included the BIE because this form fits nicely with the BIE, a buyer's inspection elections. If the buyer, goes down, does a BIE and clicks off about 15 different investigations they want, but then finds out that's going to cost them money, like our buyer, and now doesn't want them. Well, we're going to first of all refer to the fact that the BIE listed a bunch of inspections or the BMI listed something that they wanted checked out. And then it goes on to say that the buyer has inquired and inspected those situations. And then it goes on to say that the buyer is now satisfied as a result of his investigation or is waiving his concern and now wants to move forward with the transaction. And then when he signs this, it satisfies any issues he raised with the BMI. Now, let me just comment and then I'll wrap it up here. The BMI is only required when we represent the buyer. We have no duty to require a BMI. We wouldn't want one. If we got a BMI from a buyer's agent, I guess we could put it in the file. But we're not charged with assisting the buyer in making sure the home doesn't have any problems that they're concerned about. We don't advise the buyer. We represent the seller. So when you represent the seller only, forget about the BMI, forget about this form. But when you represent the buyer, the BMI, a very important form. And again, if there's anything on the BMI other than none, the buyer's satisfaction of investigation. Okay. Folks, that wraps it up. I'm going to stop my share screen and ask. I don't know. I hit a wrong button here. I don't know. Okay. So does anyone have any questions? No.
Well, we had a few questions located in the chat that they were hoping that you would answer for them. One of them from Carol Lafitte in our Antelope Valley office, and she's wanting to know when buyers are removing the contingencies or removing the inspection contingency up front, how does that impact the receipt of disclosures? The seller is required to provide the disclosures within 7 days after acceptance as usual, but how does it affect the inspection contingency because it was removed up front?
Yeah, now that's a great question. And there are two issues, but they sort of lump together. The first issue is statutorily required disclosures cannot be waived and include a right of rescission. So if you remove your contingencies up front and then you get a TDS, it doesn't matter that you removed your contingencies. You automatically get a 5-day right of rescission. So a shrewd buyer's agent could remove all their contingencies with their offer, and a foolish listing agent doesn't give them the TDS before the buyer writes the offer. Unequivocally, the buyer has a right of rescission when they get the TDS. So the way to avoid that is, if you're the listing agent, provide all of the statutorily required disclosures prior to the buyer writing the offer. So if you received an offer and it was, no contingencies, you would send the offer back and say, before you provide me this offer, I want to make sure you have these disclosures. Now, the statutory required disclosures are the TDS, the natural hazard disclosure, the lead-based paint, and now the new fire hardening disclosure, if it's required. So removing contingencies up front and then getting the disclosures negates that. To get around that, give the disclosure ahead of time. The contract also gives rights of rescission for certain disclosures provided during the course of the transaction. That could be problematic. So I would argue you should give all your disclosures prior to the buyer writing the offer to make your non-contingent offer relative to physical condition. Now, a loan contingency isn't affected by disclosures, but the physical investigation contingency are. So provide the disclosures up front. Hopefully that answers the question.
It does. And with that being said, there still probably needs to be documentation that the buyer has reviewed all statutory disclosures, perhaps a list of the disclosures that they reviewed prior to writing the offer. Just because they reviewed them ahead of time, it doesn't mean it's documented in the offer when you're writing it. So if you are the listing agent and have provided them up front when the buyer writes an offer, should that be listed in a counteroffer that the buyer has reviewed and accepted all statutory disclosures?
Well, you could put that in a counter offer. A better approach would be to simply require those disclosures to be returned with the offer signed by the buyer. So you send it, so you find out that the buyer's going to write a non-contingent offer. So you say, okay, before you write it, let me send you the TDS. And I keep saying before you write it, because Civil Code actually says before the buyer prepares their offer. Doesn't say before the offer is accepted. So so you get the offer, or you're told the buyer's going to write the offer. You send over the TDS, and then you want the TDS signed and returned with the offer. You want the natural hazard disclosure, that front page signed and returned. If you have a lead-based paint requirement because your house is old enough, signed and returned. Again, same with the fire hardening. Those two, they may or may not apply depending on the property. But the natural hazard and the TDS apply to any the natural hazard applies to any property. The TDS 1 to 4 residential units. So yeah, document that you got it. Ideally, their signature on the disclosure, and the date is, equal to or prior to the date of the offer.
Okay, so another question as a follow-up to that is from Dave Zeman. He wants to know if they put the disclosures in the initial MLS as an additional document section, are they considered delivered prior to writing the offer? That's
a great question. No, they're not. So you put them in there, but again, you want to verify they were delivered because they have to be received by the buyer or the buyer's agent. And that's a great question. That courts have actually addressed that. And putting them in the MLS facilitates getting them to the buyer, but you want to document the buyer got them. Simply having them in the TDS won't protect you. In the MLS won't protect you.
Perfect. Okay. And then we have another follow-up question from Vicki Barnles. She has a current escrow where Redfin is the seller. They do not occupy the property. However, they forgot to check the box on the TDS section 2. Does that open up the rescission period and or the ability for having the right to cancel?
What didn't they do in section 2? What box didn't they check?
They did not check the box that says whether they occupy or do not occupy the property. So they didn't complete the TDS in its full, Vicki, which means that technically it's not a completed TDS. So it does open up the right for you to have time for your buyer to review that full, corrected.
It's a technicality. I would caution your client that, we're not adjudicators and we can't predict the future, but the law is pretty specific. And I have successfully argued with an attorney, no less, in a transaction. The attorney was a high price Laguna Beach attorney, and they had not completed the TDS. And we'd removed all our contingencies. And then we had discovered a problem we should have been checked into before we removed our contingencies. We didn't. I won't name the agent, but that's all right. These things happen. I was able to argue with that attorney. Look, the law is pretty straightforward. The law says every question that's applicable must be answered. So you don't have to check dishwasher if you don't have a dishwasher, but you do have to check, are you living in the property or not? That's a either or. So the fact that it's not checked, technically it's not been delivered. And again, repeating myself, I wouldn't want the buyer to go to the bank on it, but one could argue and probably prevail. You did not deliver the TDS. You did not complete it.
Okay, another question with the same situation. They also Redfin didn't check the box in section 1 of inspection reports completed. They put no substituted disclosures, but then they did provide prior inspection reports, and we do have a receipt for reports. Is that fine for sellers to do one or the other?
Fine. Right. You can provide additional reports and not list them on the TDS, but you have to check one of those boxes.
Okay. Okay. That's good to know.
Other questions, Cheyenne, in the chat?
Yep, there's one more question for you. It's on the Megan's Law disclosure, and she's curious if that's still required for our files. Now, Megan's Law disclosing that is a requirement. It's whether or not the separate form in and of itself, by itself, is still required by our offices.
Right. Civil code requires that buyers be told there's a website. And the Megan disclosure, initially, the separate standalone form was created before CAR went in and amended the purchase contract. So in the interest of saving a few trees back when we had paper documents, they said, we'll put this in the purchase contract and you don't have to do the disclosure. It's the same with the underground gas lines. Civil code requires that a buyer be told of the website of where they can locate underground gas lines. So, but interestingly enough, I don't think CAR ever created a standalone form for that. By then they'd figured out we can put that in the RPA. So the RPA is enough. You do not need a standalone Megan website disclosure because the RPA has it in there.
Perfect. Yep, that's absolutely right. So Megan's Law as a standalone form is not required because it is disclosed in the purchase contract. It is required to disclose, but it's disclosed in another form, so we're good to go. Okay, Nora has a question, and Nora, I'll go ahead and present it a little bit, but I have some questions on your question. It says, what if an agent tells you they knew of a bad roof, but didn't write it in the TDS? I'm assuming you mean that the agent tells you the seller was aware that they had a bad roof and the seller did not put that in the TDS. And then she writes, also the AC does not work and they also did not put that in the TDS. So they have a TDS. TDS is filled out correctly, but it was missing very important information that should have been disclosed. What do we do now?
Well, technically, I mean, a seller only discloses what they know. So if they knew the AC wasn't working, but they didn't answer that correctly, then they delivered the TDS, but they committed is a harsh word, but it's the correct word. They committed a fraud. They basically lied. So that would be one issue. You'd have to be able to prove that they knew it. And more importantly, you relied on, to your detriment, they said the AC was working. But I would argue, I don't want to get in the weeds here, but I would argue you're not going to prevail on that argument because you know it doesn't work. So it's sort of like, if I'm not confusing you and if I understand the question yet, right, if a seller does not disclose they have a cracked slab, but they knew they had a cracked slab. The carpet people came in before they sold the house and replaced the carpet and told them, hey, you got a cracked slab. And they said, don't tell anybody. So then they don't disclose it. And then the physical inspector comes in and says, you got a cracked slab here. The seller's off the hook because the buyer found out the truth. So the seller is not going to get in trouble for lying, although you'd think he should have, but he didn't. So it's similar to you with the AC. If the seller says my AC is fine, but you're told no, it's not, the buyer doesn't really have any action against the seller for misstating on the TDS.
I'm more concerned about the roof because the roof, the inspection showed water marks all over the top of the garage, the sheathing in the garage and the attic, and it needs a new roof. We had a roof inspection done. And so when I the agent called me, where's the request for repair? I said, I'm just getting a couple more estimates, that it needs a new roof. He goes, oh yeah, they know that. They know the roof is shot. Well, why didn't they put it in the TDS?
Well, they should have, but it's a moot point because now you know, and you've had it investigated. So just move forward with, dealing with it. And hopefully you're not dealing with a seller who says, no, there's nothing wrong with my roof, because now you'd have a bigger problem. But the seller's going to say, yeah, my roof is not, I know. So it doesn't really matter. Yeah.
Okay, we have another question from Vicki. Vicki, do you want to just take the mic and ask this one since it's a little involved?
Oh, sure. So the BMI, I was just wondering if it's a good idea as a listing agent to have buyers sign it, because I had a scenario in Coronado where I represented the buyer and the listing agent had put that there was air conditioning and there was none. The buyer was savvy enough after close of escrow to go after the listing agent and was successful in getting them to pay for an air conditioner. But in the BMI in paragraph B, it talks about representation of information in multiple listing service. So I'm just wondering if this would be good to have as a listing agent to have a buyer sign off on it.
Probably not. Civil code, civil code specifically allow. That's why your buyer got the air conditioner. That's happened to us a couple of times over the years. Civil code allows a buyer to accept the representations in the MLS as factual statements made by the listing agent.
Right.
Right. So so the BMI, the fact that it has a generic disclaimer about the MLS is not going to relieve the listing agent of making a false statement in the MLS. And again, it's constructive fraud. Constructive fraud's a harsh word. Constructive fraud is you should have known better. You didn't deliberately lie. You didn't say, you know what, I'm going to lie. I'm going to tell them there's air conditioning. I know there isn't. But you said there was air conditioning and there's not. So you made a false statement. Even if you didn't know it was false, it's still constructive fraud. And constructive fraud is actionable. That means, you can be responsible for it. For damages people suffer. And then this civil code, I think it's either 800 or 900. 800's, I think, construction. But there's a civil code section that basically says anything the listing agent puts in the MLS, that if it's not true, that is constructive fraud and is actionable. So you're not going to protect yourself by making a mistake in the MLS by having a BMI in your file.
Okay, that makes sense.
On that same issue, just to clarify this, because I get this all the time, the MLS says information deemed to be accurate but not reliable, or however they say it. I'll have listing agents say to me all the time, well, I'm off the hook. No, you're not off the hook. That's in the MLS to protect the MLS. If that worked, you could put anything in the MLS and say, yeah, look, the MLS says, I don't know, it may not be true. So that generic statement doesn't, protect you against the civil code that says you make a false statement in the MLS, you could be liable for it. Does that help?
Yes. And along that same line, and Dave Zeman, I'll circle back around to your love letters in a second, but we had a follow-up question from Linda Stogsdale in the Antelope Valley. She says, if the MLS states that there is a microwave, and in fact, there's not a microwave, will the agent need to provide one? Also, there is an air conditioner, but no thermostat to test it, but the TDS states it works. So she's curious about those two issues. And Linda, just so you know, does the agent have to provide one? Not necessarily. It's a seller responsibility. The seller has claimed that those things are in the property. But do you want to take on that air conditioning and no thermostat to test it?
Yeah. Now, one of the things, and it sounded like that, and maybe I need to listen better. I apologize. If the MLS makes a false statement, or the seller makes a false statement, but then later you find out it's false, your damages, your ability to go after either the agent or the seller are severely limited. Now, if you find out later and it was too late to do anything about it, well, then you still have, what's called actionable, you're still actionable. But if you're early in the transaction and you find out there's, it says it has a working microwave, but the physical inspector said it doesn't work, you don't have anything. If you never found out and now you closed escrow and you said, hey, wait a minute, you said it has a functioning microwave and the microwave is fine, but it doesn't work. Now that would be a claim you could make. And again, it would be a claim, you'd have to prevail. But it sounded like in the question that the buyer is aware that those false statements were made. And so is there a way to go back after the agent? No, not really. I mean, I'll give you a good example of what happened. And I confirmed it with an attorney because the buyer was so upset over it. And I just wanted to be able to say, okay, you know, you won't believe me, maybe you'll believe the attorney. But the listing agent said the heater was gas. It's clearly, it was in the MLS's gas. The TDS said it was gas. It was clearly a gas furnace as far as the listing agent and the buyer. I mean, the seller. Turns out the heater was electric. The buyer finds out it's electric for themselves about 3 months after close of escrow when they find out, why are we getting a $500 a month heating bill, electric bill rather, when I got a gas heater? You don't have a gas heater. You have an electric heater. And guess what? It's in the physical inspection. It said electric heater. So I told the buyer, that's the story I said earlier. I told the buyer, I'm not an attorney, but you're not going to prevail. And they were so upset. I did talk to an attorney, and they weren't upset with me, but they asked me to confirm what I was talking about. So I did. And of course, I knew the attorney would say the same thing. No, you got knowledge that was not accurate. So depending on when you find out that the microwave doesn't work, has a big impact on whether the listing agent owes you a microwave. If you found out about it, prior to being damaged by it. Now, you could argue this happens with air conditioning. I tell agents all the time, buyer thinks it's got air conditioning. You find out halfway through escrow it doesn't, but they wrote an offer. So you give the buyer the opportunity to cancel and get their deposit back because their offer may have well included in their mind the cost of an air-conditioned house. So you've got to give them an avenue to recover, but you're not going to get a free air conditioner unless, it's 2 days before close of escrow when you find out. Now it's too late for the buyer to do anything about it, and you might owe them an air conditioner.
Yeah, that's a good answer, Walt. And Linda, it's such a sensitive topic because there's so many answers to the question and so many examples we could give you in this scenario. But for something like a microwave or something simplistic like this, you've got to ask, are you under contract or is this after the close of escrow? And how big of a line item is it? So for something as simple as like a microwave, or sometimes a seller will say that the refrigerator is going to stay and then they take it. A lot of these things end up getting solved between agents after the fact, regardless of whose responsibility it was. Because, what are you left with? Are we talking small claims court because this is a small line item? Or are we talking some sort of a major issue like a system or component like Walt was discussing where the gas ended up being electric? That's a pretty big deal. A transaction that we had at All Pro in the past said there was a 2-car garage, and there was no 2-car garage whatsoever. That was a $10,000 check that we had to cut back to that buyer after the fact. So you have to really ask yourself, what's the cost of it, and which was the right way and the wrong way? And are you in contract, or is this after the close of escrow? Something as simple as a microwave, I think, would easily be handled between agents. The AC is a pretty big deal. If you're under contract and there's no thermostat to test the AC with, then no one could really claim that AC is in working order if it's not tested. So you wouldn't have a report to that fact. And I think that you'd have to disclose that to a buyer, that just because the seller said the AC works, we have no inspection stating that the AC works. So you either install a thermostat, ask a thermostat to be installed, or your buyer has to accept some sort of responsibility that it may not, in fact, be in working condition. So it's things that you need to, these are definitely broker specific questions that if you're under contract, call us and we can help you draft a request for repair or advise the buyer that there's some responsibility with those particular issues. But feel free to unmute yourself if we did not answer that question for you thoroughly. Kimberly has a question for us as well. Walt, she says, my client had mentioned to me that there was a crack in the slab when they bought it. They had it investigated before they put the new flooring in, and it was fine. After my seller filled out the TDS, I noticed that he did not check the defect in the slab on the TDS. Should I have him go back and check and initial that on the TDS?
That's a great question. You can suggest to the seller, you told me you had a crack and it was investigated, and And the phrase you would use is, I was told that it wasn't a problem, not that it was not a problem, that it was fine. I believe it's not a problem. So you can believe whatever you want, and you can't be sued because you have a false belief. You can be sued if you make an affirmative statement that's false. So never say, but it's okay. You can say, but I believe it's okay, or I was told by the flooring contractor that it's okay. So you could ask him if he wants to amend his TDS. He may choose not to. And if he chooses not to, I would advise you that on your AVID or on a separate document, and then tell the seller that I'm obligated to disclose what I know. And the seller stated there was a crack, but the seller stated that he believed it was not a problem. And these kinds of disclosures are good to make early because they rarely are deal killers, but they become hugely problematic after close of escrow. Suddenly okay, that's a minor crack, I don't care, I'm buying the house, I would have never bought this house if I knew there was a crack issue after close of escrow. So, address it up front. And, I'll give you a bit of dialogue, by the way. It's the best response to when you get resistance either from your client about disclosing something, or when I get resistance from agents about, well, I don't want to disclose that, Walt. Why? Now, if they say, because I'm too busy and it's stupid and I got better things to do and my fingers are tired, I don't want to type, or I don't have any more ink in my pen, some non-specific crazy reason, well, that would be crazy, but I guess that's your opinion. But the minute you say, because it might upset the buyer, that's the very definition of what needs to be disclosed. So, Kimberly, in your case, when you tell the seller, you mentioned this, do you want to amend the disclosure? No, I don't want to. Okay, well, I do have to say something. Why? Well, why wouldn't I? Why don't you want me to? Because I don't want my buyers to be upset. That's exactly the definition of what I have to disclose. Anything that might upset the buyer. So, make the disclosures, even if it does upset the buyer. Usually it won't, to the point that if it does, better that they cancel now than they close escrow and sue you later.
Okay. And is that done just with him initialing and adding the verbiage, or on a separate amendment to the TDS?
I would do it with an addendum.
Okay.
I don't like initials on, lawyers don't like initials and cross-outs on contract documents, because there's a question about, did the buyer see it before or after that cross-out, even though you dated it.
Right.
Just do it with a separate, you can use the addendum, and there's a box you can check to the TDS.
Okay, the addendum. Got it. Okay, thank you.
Another thing that was in your note, Kimberly, that you pointed out was that your sellers had it investigated before they put the flooring in. Whoever prepared that investigation or did the investigation probably typed up some sort of report. So you could include that as presenting the documentation to the buyer as well.
Okay, thank you.
Excellent. Yeah. Anytime.
Walt, actually, there's another little bit of a question, or kind of just some knowledge that I want to discuss with the agents that are on the call as well. Is we have two different things that we're talking about here. We're talking about what's the proper way to fill out forms, what's the proper way to do the TDS and the AVID. But then if you think about this from the office perspective and compliance, we're checking off and approving the documents that are provided to us by the buyers, the sellers, and the agents. So sometimes, like, for example, if we see that the TDS was not done properly, or the AVID was not done properly, or the dates are mismatched, if we were to kick all of these back. So first of all, you guys don't always turn in your documents right when you have them signed. So a lot of times you might be giving our office staff these documents 20 days into escrow. If we see an incomplete TDS or we see an incomplete AVID, if we were to kick those back and ask for those to be corrected, we know that we're going to open up a potential contingency period. So there's a lot of exposure to your guys' clients by doing your documents incorrectly to begin with, and then two, turning them in later to the office, because at that point in time, there is no right way for us to handle these things as an office, because if we kick those back, we open up a contingency period that we would never want to do. So as our office protocols, we accept or review the documents that are provided. We don't make changes to those. So be really careful on things like these TDSs and AVIDs to make sure that you do them complete and accurately up front in the beginning of your escrow, because once you pass those contingency day periods, we don't want to mess with these things as we move forward as far as the office goes.
That's an excellent point, Cheyenne.
Go ahead, Walt.
And as long as we take a moment, I'll get on my soapbox here. Both Rhonda and I think it's Rhonda in All Pro and Lindsay here in United, these folks are your friend. They have a very tough job in that they've got to critique your file and tell you what you're missing, and they're a pain in the neck. But they're really not. They're the ones that make sure that a year from now, when we go into the file, everything is there that we need to protect you should a lawsuit be filed. So when Rhonda or Lindsay sends you an email and says, hey, you're missing such and such, or this isn't correct, you should, your response should be, oh, thank you. I'll get it taken care of right away. Now, so like Cheyenne says, shame on you because you put yourself and us in a very bad spot. You turn a TDS in 3 days before escrow is going to close, and we discover, oh my gosh, it's not even complete. Cheyenne's exactly correct. Prudent practice would tell us it's pointless to send it back now because we're simply opening a can of worms. But shame on us shame on the agent, quite frankly, for not allowing us to discover during the contingency window that, oh, this isn't quite correct, fix this, and that way you've got a perfect file. So get your files in early, get your documents in early so that they can be checked, and welcome the checking. The checking is another set of eyes that ultimately, should a claim be filed and you open up the file and what you need is there. When I open up the file, or Cheyenne opens up the file, or Kenny, and what we need is there, eureka, we're probably going to solve this one. But when it's not there, it's like, how low can we get away with as far as the check we write? Because we're in trouble.
Perfect. Okay. And then last question is from Susan Geisler. She says, does the verbiage in the MLS buyers and buyer's agent to verify all before COE do anything to protect the sellers and or the listing agents?
In the long haul, not a lot, because if you make an inaccurate representation, back to what I said before, there's a specific civil code, maybe it's 700. I'll look it up. But I can tell you, I reference it all the time. There's a specific civil code that says that whatever you put down in the MLS, the buyer has the right to accept that as factual. And so, you put down 2,000 square feet, and then you have a statement saying buyer to verify that, and the buyer finds out there's only 1,800 square feet. That 200 square feet is actionable if they weren't informed by an appraisal or something else that your number was wrong. You're going to quite likely be in a position where the E&O is going to say, we're settling. And, and of course, the settling means the agent and the brokerage writes a deductible check right away. It costs you money right away. And then the E&O tries to mitigate their damages because, do the math, 200 square feet at $300 a square foot. I mean, what is that, $30,000? If they can settle for $10,000 or $15,000, they're going to want to. So, the short answer is buyer to verify. It's a nice to point at. Certainly we're going to point at everything, but you're not going to win with that in all probability. You're going to end up settling. Maybe you settle because you can point at that, and so their slam dunk win is also in question, but they got a strong enough case because you made a false statement in the MLS that you're going to want to write a check. E&O is going to want you to write a check. That answer?
Perfect. Yes, that answers it. And then we have another question from Jim Supples, and he's referring back to Carol Lafitte's question regarding removing contingencies with an offer. Shouldn't we also need to have the SPQ provided prior to accepting an offer that is removing contingencies? It seems like the SPQ will be an issue that may disclose material facts that would not be included on the TDS.
Yeah, Jim's right. The contract, that's where, SPQ is not in the civil code. So there's no statutory requirement. You don't get an automatic right of rescission because you get an SPQ. But the contract says that when you get an SPQ, it opens up a window of rescission. So to stay out of the weeds, it's good to give the SPQ and any disclosure. I mean, just any disclosure at all that you have prior to them removing their contingencies. Because if you give a disclosure after contingencies are removed and then the seller provides you additional information, it reinstates that contingency period. And the SPQ would be additional information. Yes. Did I answer Jim's question? Yeah.
Perfect. Okay, everybody, it looks like that's everything. If you guys have any more questions, let us know. If not, I think that finishes out everything nicely.